Thank you, the audience, for being here as we prepare to present this research. Let me start out by saying I didn't mean to have such a long introduction, but I wanted to kind of lay the foundation. I see you laughing, Candace, but I wanted to have a foundation for how a tax lawyer ended up in this space. And I tell people it was like 3 different routes. The one route was a mentor, not a teacher. I never took a class from Dr. Thompson at Dept, but Dr. Thompson was one of the eminent sociologists. Like I say, he was handpicked to be the mentor of Dr. King, and he wrote a book on a Negro leadership class, which was a study of New Orleans in the 60s. And Dr. King was just coming on the scene, so to give him credibility, Dr. King did the foreword to the book. And then he hand-mentored him, and he talked about that. So when I met Dr. Thompson, I was an English and accounting major at Dillard. And Cheryl, my number one focus was how can I make some money? So all this notion about social activism and changes in society was nowhere on my mind. But Dr. Thompson wrote a recommendation for me to Harvard. And of course I got in and I attributed a lot to him. I didn't know exactly who he was at the time. I just know they said he had a master's from Harvard. And so whenever I would come to town, I would go see him, and he would have all these discussions about Black experience and the civil rights movement. Now, I really wasn't that interested in all that, because again, my focus was money. But as a matter of respect, I would listen. But over a period of time, I realized he was depositing in me his focus and his experience, as well as his aspirations and disappointments about where the Black community was going. And one of the things he emphasized was we don't know our history, and we don't know our research, and we don't know the mindset that got us in the space that we ended up in. Most people think it just happened. He said, no, there was an intentionality. And as a sociologist, he was able to study it, and he and W.B. Du Bois and Lee Franklin Fraser and many others, and then they were able to come up with remedies and give leadership. So let's get to our program now. Our program is on unveiling the true intent of the 13th Amendment. And I understand, and I start out by recognizing that when you talk about the 13th Amendment and you talk about the legacy of President Abraham Lincoln, that you're really touching what they call the third rail. That if you want to get blacks and whites, riled up. And my grandfather over here, he bragged that he was a member of the party of Lincoln. And when they chastised him for voting for Nixon, he countered back and no, I voted for the party of Lincoln. So that generation, up until the 1960s, the Republican Party was primarily the preferred party for African Americans, and primarily because of the notion that Lincoln freed the slaves. So to start on that, let me just start with Frederick Douglass' eulogy of the Emancipation statute on April 24th, 1876. It was the 11th anniversary of the death of President Lincoln. And I was hiding behind Maryland's favorite son, Frederick Douglass, and then as my introduction. Here's what he wrote in 1876. Quote, he was preeminently the white man's president, entirely devoted to the welfare of white men. He was ready and willing at any time during the first years of his administration to deny, postpone, and sacrifice the rights of humanity and the colored people to promote the welfare of the white people of this country. In all his education and feeling, he was an American of the Americans. He came into the presidential chair upon one principle alone, namely opposition to the extension of slavery. And then later on he said, he was willing to pursue, recapture, and send back the fugitive slaves to his master, and to suppress a slave rising for liberty. Though his guilty master were already in arms against the government, the race to which we belong was not the special object of his consideration. This is Frederick Douglass, 11 years after the death of him. And he ends by saying, we were not the children. He said, you are the children of Abraham Lincoln. We are at best only his stepchildren. This is Frederick Douglass. Now, he gave me another eulogy within months of President Lincoln's assassination. That's the one I had always read. And that one he said he was a black man's president. He said black people love Lincoln. And he talked about all the things Lincoln had done to free the slaves. So we're here today, and my research will help to explain these two different divergent views. It helps to explain why everybody has different views about Lincoln. Now, Lincoln was at most a preeminent politician. And I've been around a lot of politicians. And the first thing you learn about politicians is do not delude yourself into thinking that you know them. Because good politicians know how to become what they need to become to get what they need to get done. So they may be one thing one day and a totally different thing by the afternoon, depending on the audience. And the most mistake you can make is to say, I know them. And that's where I think President Lincoln was. People have said he grew. And I said, well, how can a politician that's known for being an eminent politician, how can you ever say he grew? You first have to start out with what was the foundation. And then you're going to deal with the change. But if you're dealing with a politician that can change his stripes at any point in time, now you got to ask yourself, what did you really know? And did you know what you thought you knew? So the second introductory comment I want to make is from Senator Daniel Clark. This was made in 1864. He said, yes, sir, slavery in the United States owes its giant growth to the Constitution. Not that it was created by it, for it existed before it, but that it was planted in it, fenced around and protected by it, so that no national power could weed it out short of an amendment to the Constitution. This is after the enactment of the 13th Amendment. So what my research is primarily going to show, everybody has already documented, even the Verne program, the 13th, on how the Accept Clause created prison labor. Many books have been written about it. I'm not trying to recreate that. I'm not trying to invade that space. Books have been written to show that how the 13th Amendment primary effect was to re-enslave rights. Athletes, that's been written about. That's not for debate. And that's what the senator said. That although the 13th Amendment is viewed as liberating blacks, it also resulted in what we now call the prison-industrial complex. One article said there were more blacks enslaved in 2007 than there were in 1863. Why? Because of the prison system. So when I looked at these, I approached it from a legal standpoint, and my approach was real simple. Was this intended? Not the consequence of it. We know what the consequence is. We're living it. But was this intended? And could it have been avoided? So in a nutshell, I did what we did as tax holders. What tax lawyers are known for, people say we exploit loopholes, and we do. And I worked in New York for the top tax firm in the world. That's why I mentioned that, because we represented some of the wealthiest billionaires in the world. And when you're working for billionaires, there's one thing you cannot do. You cannot make a mistake. The second thing you cannot do is you cannot do bad research. So one mentor taught me, and I approached that to this. He said, if somebody asks you what day comes after Sunday, what's the answer? Well, I looked at him and I said, Monday. He said, bad answer. I said, what? He said, the answer is, I don't know. I need to look at the calendar and see. Because we're taught you can't say something exists until you see it. As basic as that. And to add that joke, one day, Congress passed a bill that Thursday didn't end until 3 o'clock on that Friday. Because they had a bill they had to pass by deadline. So it's recognized that Congress has the power, like daylight saving time. They have the power to change the calendar. And so I approached it. So I couldn't say anything, and I wouldn't say anything until I what? Until I saw the research. So I wanted to see, and I went to the legislative history, I wanted to see what did they talk about when they talked about the except clause. That's what everybody said. Now, I don't want to make a mistake I made when we first did this. Let me read the 13th Amendment. I don't want to assume that everybody knows what it says. Here's what it says. Neither slavery nor involuntary servitude, except as a punishment for crime where the party shall have been duly convicted, shall exist within the United States or any place subject to their jurisdiction. That's what it said. Now, I got introduced to this also. I had a client. I didn't do a lot of criminal representation, but I did some with a special favor. And one of my clients I was really beaten down. I always Cheryl gave this basic thing. That if I get you off this, I'm going to get you off. But if you commit another crime, I'm going to get a baseball bat and beat your brains out. That was a trade-off. And he said, why would you do that? I said, real simple. The next time you may rob my mother. You may rob somebody I know. And what I want you out on the street for? So if I get you out, afterwards, to put me in my place, he said, I bet you don't know the 13th Amendment didn't end slavery. And I stopped and looked at him like, where is he going with this? Everybody knows the 13th Amendment ended slavery. He said, no, it didn't. And I said, look, you call yourself a Harvard-trained lawyer and you don't know the 13th Amendment didn't end slavery? I bet you never even read it. He was halfway right. I hadn't read it in so long, you didn't have the internet then. This is like 20-some years ago. So I went and pulled it and looked at it, and he pointed to the except clause. And that stayed on my mind. So about 3 or 4 years ago, I decided to take it up as a project. And so what I found, I'm going to get to the end first, then we'll put the background. What I found, that the history of the except clause, as far back as slavery has been in this country, has always been the same. And that was to target free blacks. That blew my mind. The first slave statute that was introduced in Massachusetts in 1641 had an except clause. Now, that slave statute is important because Massachusetts was a colony. And when it passed, it was the first one to legalize and recognize slavery. It did not enslave free blacks in Massachusetts. So it wasn't like they passed the law on day one, then day two, every black got enslaved. That didn't happen. What the law literally said was, if you, first it started out, let me read it so you can see the similarity. It starts out, and you'll see it sounds like the 13th Amendment. It says, there should never be any bond slavery, villainage, or captivity amongst us, unless, it didn't use the term except, they use the term unless. And here was the unless. Unless there be lawful native captives taken in just wars, they were natives, or such strangers as willingly sell themselves, that's a voluntary servitude, or are sold to us. The only slaves black and enslaved were those already enslaved and brought into Massachusetts. Now, it's not saying they'll never be. And it's in the except. So in English, they call that the double negative. And that's what the 13th Amendment used. So in legislation, when Congress uses the double negative, it's designed, just like Trump has done with the Big Beautiful Bill. People hear the first part, and they don't look at the details, and they don't realize it's really saying, this is when you can have slavery. It starts out by saying, neither shall there be any slavery, but when you do the exception, it's really saying, these are the conditions you can have slavery. So the 13th Amendment said, basically, you can have slavery if you're duly convicted. That's what it effectively said. Now, the old form of slavery, chattel slavery, ended, but this new form began. So there were many blacks who were, slavery was going to end, and so the criminal justice system became the new middle passage. And here's what I mean by that. Rather than being taken from the shores of Africa, put on a ship and shipped over to America, you can wake up in the morning free, you can get arrested at noon, and you can be a slave by 6 p.m. in America. So the first slave statute in 1641 says, this exempts none from servitude who shall be a judge thereto by authority. In other words, duly convicted. So what I wanted to show you first is, this is called the first slave statute. It's in a body of law called the Body of Liberties, but it's authorizing slavery. It's not unlike the 13th Amendment, which is called emancipating slaves, but in it, it authorizes what? Slavery. So once I got past that, now my issue was this intentional? When I first started doing this research, it took a long time. And after I did this presentation, it may take an hour and a half just to lay the foundation. But after the research got crystallized, it can make a real story. First and foremost, the key to understanding this is understanding the state of Illinois. The Lincoln, I think, what's the motto for Illinois? Land of the free or something like that? Well, Illinois is the key to understanding where we are right now. Because Illinois was a unique state. It was probably one of the most unique states in the country. Because of the way it was created, it could not have slavery. Now, Louisiana and Mississippi, they could vote to have slavery. But Illinois could not. Because the Northwest Ordinance of 1786, from which it was formed from, the land when it was donated by Virginia and Thomas Jefferson, stipulated that any state made from this particular land could not have slavery. So they couldn't even put it in their constitution. They couldn't even vote on it on a referendum and say we want to have slavery. All the other states could, but 4 or 5 states, Illinois, Indiana, Ohio, couldn't do that. They couldn't have slavery. But guess what? They always wanted slavery. So they're stuck with, they could not have slavery, but they always wanted slavery. So what did they have to do? Come up with exceptions. They had to come up with ways to have slavery. And one of the ways they came up with was through the criminal justice system. So they had a statute that basically said, and I'm going to talk about the case, Nelson versus the people of Illinois, which is a key point to the 13th Amendment. Nelson was a mulatto, it said. The statute said if a free black moved into Illinois and stayed too long, it was a crime. Because they didn't want, only blacks blacks they wanted were slaves. If they couldn't have blacks as a slave, then they won't any free blacks there. So Illinois passed this law that said if you stayed too long, it was a crime. So what was the punishment for the crime? It could be prison. It could be a fine, or you could be sold into slavery. That's 1848. That's Illinois. Their constitution. So Nelson stayed too long. They sentenced him. He sued. Now the irony is, the drafter of the 13th Amendment, Senator Lyman Turnbull, is from Illinois. I'm going to wait that out. Oh, great, keep talking? Okay. Well, he told me that every student that came in late would bring me $5. So I'm really not waiting for that, I'm waiting to get my money. So Nelson sued. So Nelson sued, and he said, hey, I can't be a slave, because Illinois Constitution, let me read it to you. Illinois Constitution is very important because it is almost exactly the same as the 13th Amendment. Not exactly the same, but it's almost exactly the same. Here's what it says. It declares that there shall be neither slavery nor involuntary servitude in this state, except as a punishment for crime where the party shall have been duly convicted. That sounds familiar? That's the Illinois Constitution of 1848. That's not 13th Amendment. That's the Illinois Constitution. Now, who's from Illinois you know of? Lincoln. Lawyer in Illinois. You think he didn't know about that Constitution? Senator Lyman, who drafted and was over the Judiciary Committee, who responsible for the 13th Amendment, not only was he from Illinois, not only was he a lawyer in Illinois, but he had just come off the Illinois Supreme Court. You think he didn't know about that provision? So when you look at the legislative history, they say, oh, we got this provision from the Northwest Ordinance, which is the Northwest Ordinance was a foundation for not just the U.S. Constitution, but the Bill of Rights. The Northwest Ordinance is considered the blue standard, gold standard for legislation. So he said, oh, we got it from there. Now, it's similar, but this one is pretty much exact. Now, why does that make a difference? Because one of the number one rules in drafting contracts, and Attorney Higginbotham can confirm this, is you don't want to put a provision in a contract unless you know for sure how the courts are going to interpret it. That's the difference between a good contract lawyer and a jackleg. You know, a jackleg, you don't know, you just write it out. But a good contract lawyer has to know how will this be interpreted by the courts. Now, here's what's key to it. Nelson sued. The Illinois Supreme Court ruled. They issued their ruling in January of 1864. And in the ruling, what they basically said, I'm going to summarize it, is, I know the Constitution of Illinois starts out by saying, neither shall there be slavery nor involuntary servitude. I know that. But it also says, unless they're duly convicted. And what the Illinois Supreme Court said is, notwithstanding this language that said, neither shall there be, the state of Illinois has the legislature has absolute police powers. They can pass whatever law they want, and they can stipulate whatever crime they want to have, and they can stipulate what's the punishment. And no judge can second guess that. Everybody hear what I just said? See, the way our country is set up, under federalism, there's certain things that are reserved to the states. And one of the things reserved to the states is their criminal laws. In fact, that's what the slave states relied on to say the federal government can't make me in slavery. Because they said, I got the right to define what's property. And guess what they defined as property? Those of African descent. That's the foundation for slavery. Because the state said, we have a right to do this. So when the Illinois Supreme Court did the ruling, here's what it said. In the case of Hells versus People, some case, it was said that a state has the power to define offenses and describe the punishment, and that the exercise on such powers cannot be inquired of into by a court of justice. In the rightful exercise of this power, the legislature has declared the immigration of persons of color to and the settlement of this state as an offense and declared the punishment. The courts are not authorized to say that such an act is not a crime or that the mode of punishing it is improper, nor have they the right to determine that the best mode of enforcing this constitutional provision or by some other than by punishing the act as a crime. So it's constitutional to enslave these people, even though the Constitution says neither shall they be slaves. Now, why is that so important? Because in January 1864, something else happened. Everybody know what happened in January 1864? They introduced the 13th Amendment. You think that's a coincidence? January 1864, this Supreme Court of Illinois case comes down. January 1864, they introduced the draft bill that became the 13th Amendment. January 1864, it becomes the foundation. They already know what the courts are going to say. Now, the except clause has another name that I never knew went together. Another name for the except clause are black codes. Anybody heard of black codes? Right. Now, I heard of Jim Crow laws. Jim Crow laws were laws passed by the South after the Civil War. They didn't mention black. They just targeted blacks. Black codes, though, were laws passed before the Civil War. And they expressly, like the one with the mulatto, talked about blacks. In fact, Maryland had one. And I have it here. Maryland is before the Civil War too. And theirs expressly said, we're targeting free blacks. And Maryland one also said, how they can be sentenced. Some could be sold in the state. It was a real bad offense. They could be sold outside the state. But they could be sold into slavery. So before the 13th Amendment, before all this we're talking about, this practice was already going on. Now the problem was, most of the senators didn't know about it. There's no internet. There's no TV. There's no, the newspapers are not being spread all around. So when you get to the Senate and they're having this discussion, guess what Senator Turnbull never talks about? He never talks about this case with Nelson. He never talks about this Illinois Supreme Court case that said, by the way, even though you say neither shall there be slavery, if the legislature wants to, you can sell them into slavery as a punishment for crime. And that's what everybody has talked about as a consequence. But my research is showing this was knowing. They deliberately picked this language. And here's why I say that. Because Lincoln as a representative had drafted a bill early on to outlaw slavery in the District of Columbia. And in the bill he drafted, the except clause only went to involuntary servitude. It did not go to slavery. In our Constitution, the except clause only went to involuntary servitude. It did not go to slavery. The Kansas Constitution, a same thing. So there were other options. And in fact, some commentators have said the except clause is next to involuntary servitude, and that was really the intent. And other commentators have said, look, the 13th Amendment has never really been challenged in court. And the only courts it's been in have been courts after the Civil War that were controlled by slave owners in the South. And there were no abolitionists in the South. Did everybody know that? All the abolitionists were in Philadelphia in the North. But in the South, there were no abolitionists, there were no white churches, there was nobody opposing those rich, powerful slave owners who had the claim and every other police on their payroll. So basically, it's never been challenged. But so, here's what happened. In the discussion, there's no discussion in these cases. But one senator, Senator Sumner, who's an abolitionist, said, this except clause looks like it's authorizing slavery. And Senator Turnbull, and Senator Turnbull is a complicated fellow. Well, Senator Turnbull told him, you're being picky about words. Look, the whole point of going to a lawyer is to be picky about words. So Senator Turnbull said, you're being picky about words. And he said, now Senator Sumner really backed up. He didn't push it. And here's what people suggest. About 8 years earlier, Senator Sumner was arguing with a Senator Brooks from South Carolina. And he insulted one of Senator Brooks' relatives in the whole slave-owning class. And Senator Brooks took out his cane, which he had a metal end, and beat him unconscious on the Senate floor. He was so traumatized by it, he spent months in Paris to recuperate. And while he was beating him, other senators said, let them go. This was bound to happen sooner or later. So when Senator Sumner is opposing it, and Senator Turnbull, who's powerful, and Lincoln's right-handed man, Senator Turnbull and Senator Lincoln go way back. In fact, when Senator Turnbull was running for the Senate, he beat Lincoln. And when Lincoln was elected president, he sponsored Lincoln. And there's a letter between the two of them where Lincoln says, hey, I trust you as much as I trust my best friend. You don't have to worry about me. We're in this together. So there's no doubt that they were bosom buddies. So when Senator Lyman says, you're being picky about words, this is going to wipe out slavery, it's going to do the trick, trust me, he's lying through his teeth. He already knows what's going to happen. So the last point to this, to show you about the intent, is after this happened, Maryland started auctioning slaves like they did before. And the Senate got upset about it. And they passed a bill, the House and the Senate, to say you can't have slavery after the 13th Amendment. It went to Senator Turnbull's committee, and he mothballed it. It had never come out to this date. And they said, what about it? He said, you don't need it. I'm going to fix it in the Civil Rights Bill. Senator Turnbull drafted the Civil Rights Bill, and guess what's included in the Civil Rights Bill? That same except clause. So when you add all that together, what you see is the consequence we see that came afterwards was not just foreseeable, but it was intended. And here's what I say was intended. Lincoln was not an abolitionist. He was anti-slavery. Does anybody in this room know what the difference is? I didn't know either. Abolitionists wanted to abolish slavery everywhere. Anti-slavery wanted slavery to stay in the South. They just didn't want it to spread to the North. And Lincoln is on record for that. The Republican Party was formed for that purpose. The platform for the Republican Party, and the commentators always said, it always had two provisions that seem to conflict with each other. One, they didn't want slavery to spread. And two, they recognized that the state had a right to control its domestic affairs, i.e. its criminal justice system. So when you put all that together, what you get is, when the Illinois Supreme Court made that ruling, they were doing it based on the fact that the state has a right to control our criminal justice system, and I can sentence you to slavery if I like. And the Republican platform had that provision. So they always said, when Lincoln was running, his nod and the wink and his words said to the South, your peculiar institution, talking about slavery, is safe with me. You don't have to worry about me in slavery. Said that is our inauguration. So some say that's why he really got killed. That Booth felt like he had betrayed them. In his last speech, he talked about blacks having voting rights. He had also said blacks not having any voting rights. In fact, he and Frederick Douglass fell out because he called Frederick Douglass to the White House to say, once we get the blacks free, we got to figure out what to do with them. You know what his recommendation was? We're going to ship them to another country. And Frederick Douglass said, that is the only country we got, Mr. President. What are you talking about? So how can you propose such a thing? And what Lincoln was basically saying is, Southern whites are not going to want you around if you're not a slave, and I don't want you around either. I don't want to have to deal with you. But it'd be unfair to ship you out. So that's the presentation, that's the foundation, and I took the time to lay it out because what I want you to see, I'm not just knee-jerk attacking Lincoln and his legacy, but what we're doing is to make sure that the revisionist historians who did this when there were no blacks in the legislature, no blacks in the Senate, probably any black lawyers, at that time basically said what they wanted it to say. Okay? And so if you go back to the Northwest Ordinance, which is supposedly against slavery, that provision always had the except clause just like the first one. And it also had the Fugitive Slave Act. The Fugitive Slave Act basically said, if you got free from slavery and you ended up in New York or Massachusetts, the laws of New York or Massachusetts would catch you and bring you back. Now it could have said, like the Bible said, if a slave escapes, give him refuge. Don't send him back. It could have said that. And what Lincoln stood for is he was always for the Fugitive Slave Act. And the last thing Lincoln stood for is, if the South has to give up their slaves, they should be compensated. So let's get to the 13th Amendment. They wanted to end slavery, and the South had to give up their slaves. They had to give up free labor. And what was the compensation? That except clause. Because now they gave the South the power. They were going to have to be rebuilt. The war is torn them apart. It gave the South the power to reinstitute slavery. All you had to do was pass a law that said you can't spit on Sunday. Pass a law that says you can't walk on Tuesday. Pass a law that says you can't sleep at night. Pass any law you want, and then sentence them to slavery. And so when you look at what Eva DuVernay in 13, and one guy wrote a book on slaves of the state, and all these studies, all they're telling you is that's the except clause. What I'm here to add to that discussion is it was knowing, it was intentional, but yet, as we speak today, it's still going on. Thank you.
Thank you, Mr. Jones, for that outstanding presentation. At this time, we're going to have a panel discussion revolving around many of the comments that Mr. Jones indicated, and we'll open up for questions and dialogue from the audience. Before we do that, I just want to introduce our panelists this morning or this afternoon. Dr. Anthony Jackson, if you want to show about yourself for just a few seconds.
Yeah, assistant professor here in the Department of Sociology and Child Studies. I also do work for the Prison Education Program, Director of Operations, and happy to be here.
Thank you.
I'm used to loud. So, assistant professor here in the Department of Sociology and Child Studies. I also am Director of Operations for our Prison Education Program here at Bowie State.
Yeah, my name is Michael Higginbotham. I'm a professor at the University of Baltimore Law School. And I'm always happy to be on campus at Bowie State. I have a program that partners with Bowie State. It's called the Fannie Angelos program. And my dad, who's an old school kind of guy, he's a Tuskegee Airman. He always asks me about, how many people do you have lined up for your program? It's a scholarship program where we help people get into law school. And then we pay their tuition, full tuition, $100,000. My dad, I got some big pockets here, right, full of money. My dad said, you must have 1,000 people lined up for the program. And you know what? I tell him, we got a few, but we could use some more. He always said, well, you're not hungry enough. So, all you Bowie students out there thinking about law school, you need to apply to the Fannie Angelos program by October 15. If you're a junior or a senior, because there's $100,000, a pot of rainbow, a pot of gold at the end of the rainbow for you if you're willing to take advantage of it. And you need to talk to Dr. Adams, who has all the information.
Thank you. My first question is a basic question, just the panel's reaction to the research, and did it change your view of the 13th Amendment from how we originally think about it?
We need like 2 mics. First of all, that was a great presentation. I think the language, the verbiage, like how technical, how specific, and I know it probably was tiresome clicking at all those documents, but it was very fruitful because I think that we were all stimulated by it. My view was, I don't think it's necessarily changed. I think that it deepens my understanding of how strategic, how thorough, and how far-reaching this was. I situate, my understanding of the 13th Amendment within a broader structural crisis of capitalism, state violence, and the control of Black labor. So I know that capitalism is always looking for ways to control its productive force, and labor power, working class people being a productive force. And so when we think about what enslaved men provided, a class of people that were considered property to be able to use for capitalist productive profit, right? They always need to figure out a way to control that. How do I make sure that I maintain all of the things that are going to be used to maximize my own profit? And so I think I did not know how there were seeds of the 13th Amendment already present, right? And how it culminated to this. And I think that was super dynamic.
So the question was, did I find the research beneficial? What's my reaction to it? And I found it very beneficial. Anytime you have a professor in the room who's learning some stuff, you know you're speaking some groundbreaking research. And so I would say to you, I like what you said about what day is after Sunday, right? So I think you gave the right answer today. I would say that I'm a real believer in speaking the truth. The truth will set us all free. And that's why today is so difficult in terms of the harm that's being done with You know, you can't talk about slavery in certain places. You can't talk about DEI in certain places. There's an attempt to muzzle our discussion about our history. And so I think that what Dr. Jones has done, Attorney Jones has done, I think is very, very critical to keeping this discussion, to bringing out the truth, the whole truth and nothing but the truth, right? In my view, we have a birth of a nation, gone with the wind sort of view of our history, and Dr. Jones is making sure that, Attorney Jones is making sure that we get away from that and we speak the truth. As Dr. Jackson has said, and I agree with him 100% in his characterization of the exploitation, especially the economic exploitation that has taken place. I'm a professor of constitutional law, and so I get called all the time. People keep saying, hey, I know your face. And I say, you probably saw me on CNN. And when Trump was president, first time, I used to get a call from CNN every time Trump would say something racist. And so candidly, I was on, right, once a week for about 4 straight years. So I'm a professor of constitutional law with specific expertise on racial discrimination, the Reconstruction Amendments. And so what I would just say to all of you is definitely you want to read what Attorney Jones is doing in terms of his research. You want to understand the good, the bad, and the ugly about it all. But our history, as a constitutional law professor, our history has always been that we have laws and we have exceptions anytime it deals with race. And so when Attorney Jones talks about the exception clause in the 13th Amendment, he's just talking about a long history of exceptions, going back to the 3/5 clause in the beginning, right? Anytime you look at Jim Crow legislation, Plessy versus Ferguson, right? There's always an exception. The exception in Plessy was, of course, wet nurses and any assistants could be in the training, even if they were black, could be in a white car. So there's always exceptions, and the exceptions tell you more about the real purpose than the law itself or any statements that the legislatures have made about what their purpose is. So when Attorney Jones talks about the intent of those who drafted the 13th Amendment, and will exclude Charles Sumner, Senator Sumner, I like your reference, because there were some people that were dedicated, and perhaps that beating, altered a little bit of his dedication, but he was dedicated, as well as some others. You can talk about John Brown, you can talk about Frederick Douglass, folks that said, I don't care, you beat me, you can do anything you want to me, but I'm doing the right thing. Do the right thing, right? I'm doing the right thing. And so when you start to think about the 13th Amendment and those who formulated it, that exception clause is very, very problematic. And that's why Attorney Jones's research is so valuable, because that exception clause tells you exactly what the real deal was, exactly what they wanted to do. And so if there's ever a powerful argument, and I've been focused on, okay, lay out the problem, but I always tell my students, you gotta have a solution. I clerked for a federal judge, and his rule was, you can criticize my draft opinion all you want, but you better have a way I can write it better. I can write it differently. If you don't, he basically said, keep your mouth shut. And so I always tell my students, how can we do it better? So Attorney Jones talks about this exception. How can we do it better? I think his research tells you we need to eliminate it.
Any reaction, Attorney Jones? Comments before we go to the next question? Okay. Next question revolves around President Abraham Lincoln. I know when I was first introduced this information by Curdy Jones, the whole kind of view. Dr. Jones, it's Dr. Jones. Dr.
We give you honor.
We've constituted that today. Our view of Abraham Lincoln, I don't know, it was my shocking kind of thought process when Dr. Jones presented this to me about how we all introduced Abraham Lincoln when we were young kids in school and he freed slaves, etc. This kind of gives us a whole kind of different perspective on Abraham Lincoln. So just generally your thoughts on Abe Lincoln after hearing Attorney Jones's comments.
Yeah, so I think obviously, like you, in school, we were taught that he was a great guy, he freed the slaves, et cetera, et cetera. But, you know, after doing my own research, obviously, we learned as much more than far is. You know, so I'll say this, you know, when I think back about the person, I can't take the person outside of the context from which they lived. So I always teach my students about social historical context and how important that is. And when we're reading, we have to read it in context. When we're thinking about a person, we have to think about that person in context. And I know that during the era of Lincoln, during, you know, pre-Civil War, America wanted to figure out which form of capitalism was going to exist. Was it going to be capitalism based off of industry in the North? Or was it going to be capitalism based off of mass agriculture in the South, right? These are ruling class forces that are trying to figure out how we are going to maintain power, how are we going to construct a capitalist system that is designed to make sure that our interests are protected. Well, slave labor at the time, in many ways, was competing with wage labor. You have historic resentment that white folks have had, white working class people had with black folks, because they felt like, just like, you know, today, they was taking all the white jobs. Now Trump said they take other folks up and taking all the black jobs, but playing working class people against each other was very strategic, because you don't point the finger or look upward at the ruling class strings that are being pulled. And so when I think about Lincoln, and I think about who he is, and I think about the intent, I know from research that it was all about preserving the Union, and it was all about making sure that capitalism was going to not just survive, but thrive. Wage labor competes with slave labor. You have to have a class of people that are going to purchase the products that you need to sell, right? In so many different ways. And so, what was going to happen? So it led to a civil war. And when I look back at some of the direct quotes that Lincoln said, and I wrote it down, if I could save the Union without freeing any slaves, I would do it. If I could save it by freeing all the slaves, I would do it. And if I could save it by freeing some and leaving others, I would also do that. What he knew about slavery is all about preserving the Union. He also said, I am not, nor have ever been, and you got this in your presentation, haven't been in favor of bringing about in any way the social or political equality of the white and black races. I am, nor have ever been in favor of making jurors and voters and Negroes. He continues to say that, and him, so much as any man during the time, think that there is positions of inferiority and superiority when it comes to the black and white races, and he was in favor of the superior position being assigned to the white race. Right? This is who he was. He was a man in the context of enslavement, in the context of how to control labor. Right? And so when I think about Lincoln, I think about how he is a person that sat at the helm of a machine, a capitalist machine. Right? And so I always want to say, you know, we have to be careful in how we think about an individual's role, even though it is very important. But if we think that the person themselves is the problem, and we don't look at the systemic challenges that are arising, then we do a disservice, because we believe that if we switch the person out, then, you know, maybe things will be better. But, you know, there are so many presidents that we've gone through the 13 minutes still existed, and then through so many eras, capitalism is going to find a way to preserve itself, to make sure that it protects its interest. And so I think about Lincoln in that context, and just thinking about the ties. You did a great job, I think, with uplifting how embedded not just the ideology was, but how, they bumping elbows. You talked about how, I wrote his name down, Turnbull was homeboys with Lincoln. They are his homeboys, right? And when one opposed one another, they fight it out, but nonetheless, the structure, the systemic issues, the challenges, that still stands. Because here we are today still talking about the 13th Amendment.
I agree with Dr. Jackson completely, especially when he said about, he's not surprised when he heard about Lincoln. It just kind of reaffirms what he already knew. And as an elementary school student, just like Dr. Jackson, I was told Lincoln freed the slaves, and how wonderful he was. But as a professor, somebody who studied in this area, what Attorney Jones said just kind of reaffirmed my view of Lincoln. He's a politician, as you mentioned, and it just kind of reminded me when I'm hearing about Lincoln and his ambivalence or lack of taking a strong position on the immorality of slavery anywhere. It just kind of reminded me of what Lyndon Johnson was doing in the 1960s, the civil rights movement, Dr. King and other civil rights leaders, and we're in the King building, right? Is this the King building? Oh, it's next door, okay. Almost where, that's where I went first, when I couldn't find the spot. But King had to push Lyndon Johnson, Douglas, and other abolitionists had to push Lincoln to do the right thing. And, I feel like, in one respect, I feel hesitant to criticize Lincoln too much, and I'm going to tell you why. He deserves our criticism, but not too much. And the reason why, I feel like the slave preacher who first heard the Emancipation Proclamation for the first time. And he said, Lord, we ain't what we ought to be. We ain't what we should be. We ain't what we're going to be, but thank God we ain't what we was. When I think about Lincoln and the 13th Amendment, I'm like, thank God we ain't what we was. Because while it's very problematic, as Attorney Jones has laid out, it's not as bad as what we was. And so, when I look at Lincoln, I wish he hadn't been assassinated. Because as Attorney Jones said, he might have listened to Douglas on a number of things. And so it would have been interesting to see what he would have done. Would he have signed that 40 acres and a mule legislation put forward by Thaddeus Stevens? Would he have signed that so that my dad and others wouldn't have to walk around talking about I never got my 40 acres and a mule, Would he have supported all of the radical Reconstruction legislation that Charles Sumner, Thaddeus Stevens, and other committed individuals to racial equality? Would he have signed that legislation and championed it and enforced it as it never was? I mean, that would have been something to see. And then we could sit here and talk about, things might be a little bit better than they could have been. And so when I think about Lincoln, that's kind of my conflict. That's kind of my tension. But I agree with the research that we got to be critical of what Lincoln didn't do and the positions that he didn't take.
Professor Dr. Higginbotham. That's why I started out with Maryland's native son, because he knew Lincoln. He lived with Lincoln. And that second eulogy is 11 years after Lincoln's death. And in the rest of it, and I'll ask you can Google it, he says, I'm thankful for Lincoln. Lincoln was the right man for the right time. Because he knew his country. And Lincoln was such a, it's kind of like I tell people about Trump when I get upset about this. People get upset with me, and I said, now, you got to understand Trump. And I said this way back before he was elected. I said, Trump believed in one thing. He told everybody what they wanted to hear. I'm going to get rid of abortion. He did. I'm against this. He's against it. He said, look, now that I've told all these lies, I can stand up in the middle of the street and I can shoot somebody in the middle of Fifth Avenue and nobody will care. And that's what we're getting right now. See, Trump is getting so rich, he's breaking all the laws, but nobody cares because they got abortion. Okay? And in my prior life, when I was a tax lawyer, I represented some mafia bosses. And I represented some, I didn't represent them, but I knew some drug dealer bosses. And they made their money off one thing. They get the police, they get a judge, everything they want. And then once they give them what they want, they say, now, shut up. And that's all Trump is doing. But I want to say this, related to that. What Frederick Douglass said was, let's be frank and honest about Lincoln. He was not for me. Now, my view on Lincoln is a little personal. My great-grandfather was a slave and fought in the Civil War. Lincoln was one of those, the South said, any other prisoner will keep as a prisoner of war. But the former slaves fighting us, we're going to kill. And they had to make Lincoln, and he never really came on board, but they had to make him speak out against that. He was not going to do anything to protect. Okay, and the second thing is, Senator Henderson, who sponsored, introduced the 13th Amendment, was also the senator that introduced the bill to compensate the South. See, the one thing unique about the Civil War, I didn't realize, there were 5 states in the Union that owned slaves. Okay, Kentucky, Delaware. Was Maryland one? Okay, Maryland, and I'm missing somebody. Here, there were 5. The Declaration of, the Emancipation Proclamation did not end slavery in the Union-owned states. See, it's another example of Nixon, Lincoln, I said Nixon, a tricky thing, I guess that's what I'm thinking about with Lincoln. Is that they played games with legislation, they played games with people's lives. So the Emancipation Proclamation would have applied to Shreveport because they were still in rebellion. So the slaves in Shreveport had said, you're free. Now, how are you going to be free in the South and the Union not there? But it would not apply to New Orleans in the same state. Why? Because New Orleans had already surrendered. So he really wasn't trying, it wasn't his idea anyway. Senator Sumner and another senator, Representative Hayes, who's an abolitionist, was demanding that he issue the price. He didn't want to do it. And so in a letter that Henderson wrote, he said he was coming into his office and these abolitionists were leaving. Now Henderson was from Missouri, a slave owner state, a former slave owner, and Lincoln confided in him, I don't trust those two. Those 2 firebrands, they're trying to make me do this amendment. It may be time, but I looked at it in the letter and I said he's more comfortable with the slave owner than he is with who? These 2 abolitionists. And so afterwards, Henderson introduces the bill to the slave owners in the Union that will pay you if you give up slavery. And the purpose was to tell the South, hey, they did it, if you guys do it, then the South may do it. So he was trying to come up with a negotiation to the South to say, stop fighting us, we'll compensate you, come back into the Union. And so I think that's what the accept clause became. It became the nugget, because Lincoln felt like, and he sent a letter to France that said, look, this war will not have anything to do with slavery. If we win, slavery is going to remain. If we lose, slavery is going to remain. That's what he said. And so some felt like he put an incompetent general in to fight the war because he wanted the South to give in, to negotiate, because he felt that the country was built on compromise. When the founders built the country, they let the slave states in. So they didn't have a right to what? Stop them. So the last thing I want to put on is the deviousness with the 13th Amendment is that the South wanted a constitutional amendment to protect slavery. They never got it until the 13th Amendment. Because the 13th Amendment protects slavery if you're duly convicted. And so the South really got what they wanted. They just didn't get it the way people thought they did. And that's why this congressman I quoted first off said, look, the 13th Amendment did more to expand slavery than anything it had done before. Because it gave it legality, it shut up the abolitionists, and it made people say, well, the same thing people say now. If they had committed the crime, they wouldn't have to do the time. But what people don't think about is, why is it a crime? You know, why is it a crime? So I joke with people in Louisiana, I say, if a rural person put a big tire on their truck, monster tires, that's not a crime. But if somebody tints their windows, that's a crime. Now, one of the safety hazards, that big tire gonna lift up the fender, it's gonna hit me in the head. The other one got nothing to do with me. Does it have to do with the fact that most black young boys and women tint their tire windows? And most whites put on monster tires? Because that's one of the legacies I was trying to bring out, that things are the way they are. This is what Dr. Thompson at Dillard used to say. He said, things are the way they are because a mind sat down and said, I want to make it that way. And then once they sat down and said they want to make it that way, Professor Higginbotham, they came up with something called original intent. And though they said, since I've already made it that way, you can't change it tomorrow. In other words, you're stuck with my racist ways, and even though the country may change, you can't do anything about it. And the sad part about it is, that's the way most, when I say most, I mean most African Americans, educated, allow it to be. And some say we do that because we're living in a state of extortion. We know if we speak up, some bad is going to happen. Well, I didn't mean to get into that. I'll say that for Sunday when I'm a real doctor.
All right. Well, our next question kind of focuses on what you just mentioned and highlighted in your opening statements around the intent of the 13th Amendment and the idea, are you all convinced that the 13th Amendment really provided a re-enslavement through the criminal justice system?
Yeah, I mean, I think that's easy. Like you said, there's so many pieces about how it did exactly that. But I would say, like, again, I always emphasize the way in which the economy needs labor to be controlled at the time. We have to understand that economic shifts happen first, and then the social political superstructure responds to what happens as a result of the economic shifts. Think about it. The great migration from the south to the north didn't happen until the invention of the mechanical cotton picker, not the cotton gin, which intensified slave labor, but the mechanical cotton picker, which replaced slave labor in the south. Now slave labor was needed, now black labor was needed in the north, in the industries, right? But during deindustrialization, right, what happened, right? It led to mass incarceration because a lot of folks were losing their job in so many different ways. And so when I think about the 13th Amendment, I think about how it was a strategic instrument of the control of black labor in particular, but labor in general, right? And how do I quell dissent, right? I don't know if they're gonna beat somebody with a steel-toed boot or a cane with a metal end right now. I don't know how things going. It might happen like that, and it still might be looked over. But nonetheless, right? We have to think about a way and a strategy to capture people that might dissent against capitalist production, right? And what does that look like? It looks like, okay, well, let's create laws, policies, and practice that disproportionately incarcerate people that look like black folks or that challenge my political agendas. And so I think it's another strategic tool, and I think the language that you highlighted in particular, how that language, because in the 13th Amendment, as the precinct talked about, it had the except clause, but we see prior to that, it was unless, right? That's very strategic, and I thank you for adding that insight on, the contracts, right? The Constitution, it presupposes how it's going to be interpreted. So I think that already understanding how strategic it is to create a system that is designed and institutionally legitimizes violence against bodies, black bodies, right? And during when black codes were running rampant, Jim Crow, after enslavement, after the 13th Amendment, you had the convict leasing system, right? So during the Reconstruction era, you have even though the North and the South were in this big quarrel that led to the Civil War, you had Northern industry folks that had vested interests in the South. The South had to be rebuilt. How do we do that? You just let our black folks go. W.B. Du Bois said the problem of the 21st century is the problem of the color line. What we gonna do with all these Negroes we just let from our plantations? Now was it expanded welfare? Wealth Freedmen's Bureau and a lot of different strategies created some opportunities for black folks, but it was very strategic, right? Those things were designed to sustain a population of people that you needed in the production process. The South had to be rebuilt who was gonna do it, right? So if you didn't do it voluntarily, then we'll create laws like reckless eyeballing in the South. You looked at me crazy. You looked at a white woman. Sundown towns. If you were out passing somewhere, then you just let them be free. Free. I'm out, I ain't got a pot to piss in or a window to throw it out of, and now you talking about a sundown town? Well, where am I gonna go? To jail. So that we can come and place bids on leasing you out, so you can be back on the Jackson plantation that you just left from. That's where you're gonna go. But why? Because labor was needed, and when it wasn't, there was the great migration to the north, where people were going to there were a lot of people from the north are southern transplants. If you go back, grandma, great-grandma, great-great-grandma, they came from North Carolina, Alabama, Mississippi, one of them, right? So I say that to say, in the the context of the 13th Amendment as a policy, a practice, a law that is designed to control black labor, those things are still existing now. And now, much like what you said, and I thought it was very powerful, I had never heard anybody articulate it like this way before. When you said the criminal justice system has now become the new middle passage. I mean, first of all, that's very provocative, but it's so true. And it continues to echo in our communities, right? And so, yeah, that's one.
Tell you this, I'm gonna sit in on Dr. Jackson's class. I can believe that.
I just said it.
Oh, sorry, I missed it. I agree with him 100%. Lawyers are picky about words, and so to answer specifically the question, I would say that the 13th Amendment exception clause allowed for labor exploitation, as Dr. Jackson has laid out, and whether it be convict leasing or encouraging the criminal justice system to incarcerate black people by, stop and frisk or whatever kind of practices, racial profiling, walking while black, whatever, and then to use that to exploit their labor. That's what has gone on since 1865. And so I wouldn't necessarily call it chattel slavery, because I gotta be picky with my language, but I would say it's labor exploitation to the same degree, or almost to the same degree, as occurred prior to 1865. The thing I really want to stress, though, to you, as a constitutional law professor, is not only, there are two aspects to the 13th that are important. The exception clause, but then, as Attorney Jones referenced, the intent of the framers of that amendment. Now, in my book, I talk about the Supreme Court's betrayal of Reconstruction. And so what I want you to also look at, aside from the exception clause, also in its interpretation, is to look at what the Supreme Court has said about badges and incidents of slavery. Because in the Slaughterhouse case, which is the first case to come before the Supreme Court interpreting the 13th and 14th Amendments, the majority in the Slaughterhouse case, and these were the conservatives, these weren't individuals who were considered radical Republicans. These were the opponents of equality provisions in the Republican platform. They said the 13th Amendment abolishes slavery, but it also abolishes any badges and incidents thereof. Now here's the real betrayal. And the betrayal comes from the final arbiter of the Constitution, the Supreme Court. Because Lincoln and Congress, they can do a whole lot of things. But if the Supreme Court says the 13th Amendment abolished not only slavery, but any badge or incident thereof, and we know from the Dred Scott case, where the Supreme Court said blacks have no rights that the white man is bound to respect, we know then that badges and incidents of slavery is any discrimination that occurs against black people, period. That's it. And Congress can abolish, or the 13th Amendment abolishes any discrimination against black people. If the court had said that in 1873, maybe we'd be having a different discussion today. But they didn't. What they did was they narrowly construed badges and incidents of slavery. And I'm going to give you a quote from the 1875 civil rights cases, where the court strikes down the Civil Rights Act that said there should be no race discrimination in public accommodations. The majority says at some point in the stage of their elevation, they must cease to be the special favorite of the laws and simply become average citizens. And you know what they were talking about? They were talking about the 13th and 14th Amendments, saying that somehow blacks are the special favorite of the laws. That's the first discussion of affirmative action, and that occurs in 1875. So what should they have said? They should have said what the dissenter said. Justice John Harlan, the great dissenter, right? He said, there's no distinction here. He said, any race discrimination is prohibited by the 13th and 14th Amendments. And then he said, the 14th Amendment shouldn't just stop government discrimination, it should stop all discrimination, whether it's by an individual or by the government. So he had a very broad view of these Reconstruction amendments. As Attorney Jones talked about intent, fascinating because original intent is used today, right, to stop any advancements in terms of equality, racial equality. But if you look at the original intent of the framers of the 13th and 14th Amendment, there's a whole lot of framers like Charles Sumner and Thaddeus Stevens who said, hey, these amendments are going to stop racial discrimination, period. These amendments are going to create racial equality, period. And so the Supreme Court betrayed us. They betrayed the principle of equality. They should have said, you know what? The radical Republicans, that's the intent we want to look at. And we'll have a broad view of what these Reconstruction amendments are all about to create a society where the promise of the Declaration of Independence that all are created equally becomes a reality. That's what they should have said. They betrayed us. And so I hope Attorney Jones will talk a little bit about that betrayal in his research as well.
I don't know whether Attorney Jones will.
Dr. Jones.
Well, I wanted to, one of the things I want to point out is what the research says is the drafters of this so important 13th Amendment didn't keep their notes. You know, nobody was raring to talk about it. And then after it was done, now Maryland already had this statute where it said I'm gonna sentence you. And it's like before, and Illinois had one. And so Maryland kept citizens in auction, and we came back to Congress. And at that point, Senator Turnbull, nor any other person who drafted the 13th Amendment talked about it. Intent, whether that was part of it or not, they went silent. So, and then when Senator Sumner and the others, and remember the House passed a bill to say, clarify, that's irrelevant. If they leave that alone, you can vote it now. So it was almost like they hoodwinked them. That's the term I want to use. So it was almost as if they stayed silent. They were having these high discussions. But Senator Turnbull, the language, he said, this is going to wipe out slavery in all forms forever. Yeah, they didn't talk about unless I sentence you. So I think just as an ethical matter, he at least should have brought that. Now, here's the part about Senator Turnbull that I think it was fascinating. Prior to going into the Senate, he was the #1 lawyer in Illinois to protect blacks from being considered a slave. Because one of the ways that Illinois got around it, they said he's an indentured servant. So when Illinois said you can't be a slave, you can't have slavery, so he was the #1 lawyer that would protect. So what the whites would do, they'd bring the slave in and say, they didn't make him a slave, he might have indentured servant. And then they would go to the lawyer Turnbull, and he would go to court in several court cases where he sued to free the blacks. So I have he's like the original civil rights lawyer. He was like the #1 civil rights lawyer in the country. He drafted the Civil Rights Act of 1866. So then when I got into the research, I was like, oh no. And then I found out he was on the Supreme Court. And then I found out something else that you made me remember, that he proposed a bill to make a bust of Chief Justice Tommy and put it in the Supreme Court after he wrote the Dred Scott decision. So that tells you where his heart is right there. He want to honor this man that has issued. Now the other part I need to point out is, and it'll go back to what you said, Dr. Jackson, is from the 1800s to 1865, there was 3 labor movements going on. Just to give you the background. We know the one about free the slaves. But there was a second one about free the slaves in the North. Wage slavery, they call it. white workers working with industrialists who were getting paid pennies. And then there was a third one that Lincoln came from. It's called the Free Soil Party. The Free Soil, most of the founders and leaders in the Republican Party came from the Free Soil Party. And that was the party that said you can't have slavery in the North because it will undermine the wages of whites in the North. And that's what they meant by out there. The Republican Party said in 1860 they're the party of the white man. And that's why they didn't want slavery in the North. For the same reason, Trump is about to run into problems now. He is sending out and running off all the illegal immigrants. And now the farmers are begging him, give us some money. Because who's going to pick our crops? And so that's why it's so important, because Lincoln, as a labor policy, felt slavery was bad. And I don't know if you have it around here, but in Louisiana, and somebody says, I need to get my driveway fixed. You know the next thing out of their mouth? Need to find me a Mexican. Why? I want cheap labor. And so I want to get a roof fixed on a building. The contractor gave me a price. I came up with the money, and he called me back and said, well, I can't do it. I said, why? Because my workers won't come outside. Okay, and this is what Lincoln was saying, that if you let, and this is what the Malabo case was about, if you let these slaves, these blacks up here, they're going to work for cheap, and it's going to undermine the wages. Now, the key part to this that blew my mind is what Karl Marx has to do with this. This is around the same time that Karl Marx is in Germany. This is when Karl Marx is talking about capitalism. He's talking about the American capitalism that's based on slavery. And Karl Marx, the view that the anti-abolitionists had was the exact same view, and in fact came from Karl Marx. And Karl Marx's view was America is built on slavery. Slavery gave them cotton, and cotton gave them their standing in the world. So when Trump says, make America great again, I say, you gotta ask yourself, when was America at its greatest? And it was at its greatest with white supremacy, and white superiority was number one, and everybody else was free labor for them. Okay? And so that's why it's important to understand. So the next project is going to be the mechanics of enslavement. Exactly. How do you enslave somebody? And so when I read the first slave statute, I realized that they didn't go out and snatch people and enslave them. The people came in already enslaved. So there wasn't any race war, and then whites won, and then blacks got enslaved. No, that's not what happened here. The laws enslaved them, which meant whoever controlled the legislature enslaved them, and whoever controlled the vote enslaved them. And as a friend of mine reminded me last night that if you convict them of a felony, not only have you enslaved them, but you've also stripped them of the right to vote. And so when you look at the accept clause, it's more than just about what it appears to be. It's about returning the country to a point. And remember now, originally, only white men who were property owners could vote. This is what everybody forgets about. You know, white women couldn't vote. Blacks couldn't vote. Indians couldn't vote. White men that didn't own property couldn't vote. So when we're talking about these statutes and these laws, we're really talking about white men and ladies. And they're the only ones that could vote. And they said, and my grandfather was a farmer, so I did pick cotton. But I want to pick for my grandfather and my uncle. And so I can tell you personally, owning land is about nothing unless you got labor. See, if you don't have labor, you just a broke landowner. And my grandfather had free labor, his grandchildren, his children. And we used to argue in the cotton field, and granddad, I think they fought a war about this. He said, war about what, boy? And I said, us out here picking this cotton, and you paying us these little wages. And granddad said, well, I tell you what, you don't have to pick my cotton, but you ain't sleeping in my house tonight. And you're not eating my food, and I ain't driving you back to town. So I can identify with the mindset that you come over here and you got all this free land, you maybe got 1,000 acres, maybe got 10,000 acres. But all it is a tax liability unless you got free labor. And that's when somebody said, we need to get us some labor, and they instituted the slave trade. Then next, when the Civil War was over, they said, what? How are we going to rebuild? The North is broke from the war. The South is all bombed out. There's all this. So what did they say? Well, I got you some more free labor. And so what the message, I hope the young folks get out of this, is you can rap and you can dap and you can do all that as much as you want to. But you may wake up one day, what you think is never going to happen, you're a frog in hot water. It's already happened. Labor is free. Trump is saying, get rid of DWI, not DWI, but diversity. Yeah. Get rid of that. And in fact, if you oppose us, I'm going to indict you. And if you oppose us, I'm going to do whatever I want. Why? And now they told the law firms, they told the top universities, either jump to my music or what I'm going to do. I'll take the money back. I say, what the similarity in that is what W. Du Bois said. He said, poor whites have what's called, what do you call it? A psychological wage. And that wage is, I ain't black. And that's all Trump is giving to whites, and that's why they're happy with it. You know, look, the only people subject to ICE, let me switch that. The only people not subject to ICE are white folks. Everybody else is subject to ICE. And ICE can come and snatch you up. And you ask that guy from around, they can snatch you up. While you hollering about, I got this, I got that, you on a plane and ship that. And so as blacks sit around, and not just all blacks, but minorities sit around and say that didn't have anything to do with me. I just want you to remember that's the same thing the blacks in Massachusetts said when they passed that first slave statute. It started out, it didn't have anything to do with me. But it ended up, it had a whole lot.
We have about 8 minutes left, so one final question. Do we have any audience questions?
You don't hear me? I love this. Hi, I'm Dr. Ashraf Esmail. I'm in Sociology and Child Studies with Dr. Jackson. I'm a professor of child studies. Tons of questions, but I think one of my questions is super rich conversation, but particularly in how do we transition from the space of historical context to problem solving, solution finding. So what I'm finding in conversations about the work, and Dr. Jackson knows this, and my frustration is in that the devil is in the details, right? And so I teach a child policy course, and one of those conversations is what is the solution? Because if you don't put one there, someone will put one there for you. And that clause and that language and that reading and that detail and words have power and meaning, and you do have power. But how do we move from this? Okay, I can get you to understand what's happened, but how do we start moving toward plausible, practical, implementable solution as we move forward? And that's a big question, but that's what I'm heard.
Professor, we're already working on that. Here's what the reality is. The accept clause is invalid legally.
The first conversation that nobody talks about is duly. See, it doesn't say convicted. It says duly convicted. And there's been absolutely not any research on what duly convicted means. And as Professor Higginbotham can attest, the statute has to define its terms. And it doesn't define duly. So if it meant convicted, it'll just say convicted. So duly comes from the Northwest Ordinance of 1787. It's the first one to use it. And duly in that, it meant right to habeas corpus, right to a trial by jury, right to a jury of your peers. And, you know, for the longest, blacks couldn't even serve on a jury. So it wasn't duly, it meant due process. And so there are a whole lot of questions about that. That's number one. Number two is, nobody in this country, since the enactment of the 13th Amendment, has been sentenced to slavery. And here's what I mean. What they contemplated and what Illinois did and what Maryland did is the legislature, the Constitution empowered the legislature to pass a bill, and one of the punishments was slavery. So prison labor as slavery had to be imposed by the judge. Now prison labor is imposed by the warden. And a couple of people, I think Michelle Godwin and others have written an article where they call that, not Michelle, administrative enslavement, and they suggest it's illegal. Because what they contemplated in the discussion, they said, this can permit slavery. And the congressman said, well, yeah, if the legislature sentenced them to slavery, yes. So they did not contemplate what we're talking about now with prison labor. And since one person put in prison, so the first thing is to say, invalidate that except clause, and at least invalidate the prison labor portion, because the judge has not sentenced anybody to slavery as the statute contemplates. It contemplates that part of the punishment will be slavery. So that's the first thing. The second thing is to get people to come to understand that this is slavery. Literally in the prison system. And we're sitting around watching slavery go on, even as we're upset that our ancestors were slaves. So we're sitting around watching it, being indifferent, saying they're not me. And I'll tell you, it's not you yet. And I'll end with this. I read some studies about the Holocaust. And one of the statements, I don't even know who said it, he said, when it came to the gypsies, I didn't speak up. They didn't mean another group. When it came from them, I didn't speak up. He said, then when they came from me, there was nobody to speak up. And so I'm simply saying when my dad and my great-grandfather fought in the Civil War, and what I learned from him, I didn't know I had inherited from him, was he got to be a slave. He got to be free after being a slave. He could have gone to Maryland, he could have gone to New York, but he went to New Orleans and enrolled and enlisted in the Union Army. And what he said was, my freedom is not enough. I'm willing to risk my life until all blacks are free. And that's what those blacks who joined the Union Army, who were former slaves. This is not Massachusetts 54th free blacks. I'm talking about the ones in the South. They were basically saying, I'm not going to sit around and enjoy my freedom while I know there are others that are still slaves. It's that spirit that we need to make a difference. Because you can assure me, those who've never been slaves or not subject to slaves don't have any reason to speak up. We're the only ones.
Yeah, I got a question. Pass the mic to me.
All right. One last question. One last question.
And number one, I just want to say I definitely appreciate you guys' conversation. I appreciate the discussion. Most importantly, I just appreciate the presentation. Now, you said that the only group of people not subject to ICE and this deportation is white people. Do you mind expounding on that, please?
First and foremost, ICE is looking for illegal immigrants. I don't know anybody walking around with a sign that says I'm an illegal immigrant. So they got to figure out who do you think is an illegal immigrant. So who do you start out with? You start out with people of color. So people think they're starting out with Hispanics. Well, what does a Hispanic look like? That's for starters. Because most people are mixed. And if you go to New Orleans, as a friend of mine taught me, as the Pope just reminded us, with Creoles, you can't tell if they're black or white. So when you start out saying, I'm looking for an illegal immigrant, you got to come up with an objective, and this is the problem they got all over the country. Who are you looking for? So they said, okay, we're going to places that we know Hispanics are in. Go to the farms, they with you. I told you, one place they've never gone is hotels and the casino. You can understand why. But so when you start looking at the look, then people of color, you got people maybe from Haiti, so you could be subject to it, particularly if you speak broken English. Okay, you got people from South America, brown, but people are white. They're going to presume that what? That they're here okay. Even if they're not, they don't presume that. And in fact, I say, if you look at a dialect, you can start living Melania Trump. Okay? But she's not going to be presumed to be not from here. So that's why I say whites can walk around with no fear because they're not going to be subject to it. It's just going to be people of color.
This will be our last question.
I have taught race and ethnic relations for several years. And as you started with the panel discussion, we start in terms of this particular subject matter with Lincoln as a great emancipator. And you have to counteract that, and I've always counteracted it in terms of the things he said, the things he wrote, the quotations about he, like any other man, believed in the natural inferiority of the black man to the white, and that he was put in office to save the Union, and he would save the Union even if it meant freeing the slaves. But your discussion this morning deepened my understanding when you come from this legal point of view, and I never knew the connections between the state constitutions and the 13th Amendment. I guess that's my theory. So I thank you for that. And then when my colleague here, Dr. Gilchrist, asked her question, again, your answer points to the legal system being where it needs to be answered in terms of interpretation of duly, what was it? Duly convicted and stuff like that. I wonder if then the conservative objection to critical race theory is because it originated in law schools and in the legal institutions. And so, but if we think of the law being the answer, an ultimate answer, then we still have to fear what we're seeing with the Supreme Court, which is the ultimate answer for the law. And historically, we can show, going back, as you said, to the earliest decisions after the Civil War, that the Supreme Court has always answered politically. And, anyway, my question then is, how much confidence then you have in the legal approach to solving this question?
That was a good question. That was my last question.
That was a great question, actually. I'm going to pass it over. I just wanted to say one thing, that questions like that and examples that we have of the law being maintained by a higher court of the land, being maintained in the hearts and the minds of individuals that are a part of bureaucratic operations, this apparatus, it continues to show that the ideology of white supremacy, patriarchy, and capitalism that built this country and allowed it to thrive as a world power continues to echo, right, in the hearts and the minds, but also to maintain the system. So I always think about, it's so many of us that have been subject to exploitation and oppression, the wiles of the capitalist system, and I juxtapose in this moment right now, to answer this question, I juxtapose what happened during enslavement and what is happening now, more particularly this debate on the control of labor, wage labor and slave labor led to the Civil War. And now in this moment, right, slave labor, Black folks were considered property. They were objects. That's why we talk about dehumanization. They had to be dehumanized in order to be used as objects for production. Well, now AI is changing the conditions of labor, right? Our relationship to capital is to be used to produce and maximize profit. Well, what happens when Black labor that was historically needed in great demand for capital to produce is not needed in the same way, right? Deindustrialization and outsourcing showed us that, hey, we gotta figure out a strategy to be able to incarcerate the crisis of people being unemployed, the crisis of not having people take to the streets like they did in the 60s, but to criminalize the poor. So we have mass incarceration to deal with that. We have cuts in social welfare, because why do I need to provide welfare for a population of people that I don't need in the production process? No more cash vouchers. Personal Responsibility Work Opportunity Act. No daddies in the home. How can I break up a community that I don't need as aggressively in the production process? Well, now you have technology transitioning from becoming labor enhancing to labor replacing our labor altogether. Yeah, it's impacting Black, white, Puerto Rican, Haitian, Jew, Gentile, everybody, all working class people. However, because of the legacy of white supremacy and how it has impacted the Black experience in particular, we are the first fired, last hired, right? And we are disproportionately impacted by shifts in the economy. So now you have AI becoming the new slaves. And now, how are we going to construct a system that's based on, okay, at the point of production, the masses of people are being let go because they're not needed. Working class jobs, I don't know where y'all from, but on the first of the month, you would go to a grocery store and see everybody on the checkout aisle. Now you see 2 or 3 people and you got self-checkouts. You go to some restaurants, they don't even bring you a waiter. You just type in the little thing and they bring the food out what you want. You go to McDonald's and on 14th on Georgia, and they got a kiosk where you type in and they just cook it. I mean, we have not always had access to education that sets the context for upward growth and mobility. We already know that. Now there's further attacks on education, right? And so as we are being denied welfare, as we are being denied education, is at the same time we're losing our jobs and we're being criminalized. It's very strategic. So now, if this wage labor, slave labor was competing with wage labor, and now wage labor, human labor, is competing with robotic labor, well, what is this going to lead to? A civil war or a class war, right? I think that's what we have to ask ourselves. And I think that working class people, all working class people, Black, white, Puerto Rican, Haitian, we have to transition from a defensive posture to an offensive posture, right? Defensive posture, we've always been engaged in the fight for reforms. Reform, right? Someone that is woke, that is conscious of the ways in which we have been exploited and oppressed, who has developed a racial consciousness, understands that the fight reform can only go but so far. I mean, didn't we fight for Roe v. Wade and affirmative action and all of the things? Well, what happened now? Right? So it gets to the point, see, people ain't gonna do nothing until they back us up against the law and they see no other options. Well, there's no other options now. So we have to transition from a reformative sort of struggle to, I would say, a more revolutionary, or arguably, there has to be a politicization of the working class, right? There has to be, there must be. We must use all of our power as a collective to fight for a new system that doesn't look like this one today, because it is arising. In the belly of capitalism, something is emerging. And fascism is designed to maintain the interests of white ruling class elites. So regardless if capitalists want to maintain a system or not, right? Our fight as working class people is not to bring the new system in and make sure, no. Something new is arriving, regardless if you want to fight or not. The fight is to ensure that what is arising is going to be reflective of our collective interest and not a new version of a more terrible system that we've already known, right? And so I would say the politicization of the working class, I'm thinking George Jackson, Blood in My Eye. I'm thinking a political group, a vanguard group. That's why I wore the shirt with Malcolm X and Martin Luther King, and on the back it said, all my role models were murdered by the government, right? Because it is time for revolutionary solutions and not reformative ones, but...
So the short answer to the question, I have very little confidence in the Supreme Court. I have very little confidence in Congress right now, and I have no confidence in the president. Now, that said, Frederick Douglass, when John Brown was arrested, Frederick Douglass, authorities went to his house. He was worried that they were going to discover some of the paperwork that John Brown had done in terms of figuring out what he was going to do, and that was done at Frederick Douglass's house. And so, fortunately, some of Frederick's friends got all the evidence out of there. And so, because he was thinking about going over to England, getting out of the country. I'm not there yet. I know a lot of people are. I'm not there yet. But what I would say is, hold on. Hold on. See what happens in these midterm elections. If the Democrats take the House, there will be a check put on the president. No question about that. We have a system that's set up now, and people always ask me, what's wrong? What's wrong today? What's wrong today is that you have a president that's out of control, doesn't care, as Attorney Jones said, he only cares about himself, and you have a Congress that won't stop him. And under our setup, Congress is the power, but you gotta make sure that they have the votes. And so Congress won't check the president right now. They don't have a majority of votes to do that. And the Supreme Court is a problem because you have people like Clarence Thomas and others who won't do what they're supposed to do. And so you gotta have the House put a check on it. If people vote the right way, which I haven't given up confidence yet, I believe that a majority of the American people, and perhaps a clear majority of the American people, are going to do what's right in the midterm elections. And if they do, and the Democrats take the House, and amazingly, if they take the Senate as well, you're going to see a serious check put on this president, and then we'll see what he does when he gets checked. And we'll see if he tries to go shoot somebody on Fifth Avenue, or whether he sits down and keeps his mouth shut. We're going to see. I doubt he will, but I want to be around to see that. And I really think that we may be in a position in 13 months to see just that.
I may be the naysayer.
That's why I gave you the last one.
I believe in the law. And the beauty about the law is, once you put the words down, we're all subject to it. So, I think the law, as it's set up, is the best, second best solution. Militarily, that's just not going to happen. Vote-wise, that's not going to happen. Getting the financial wherewithal to control the system. I had a conversation once with a cousin of mine, some of you may know, Jay Prince out of Houston. And we were sitting around, he and I, in Scarface, and he was talking about America. And I said, I got a question for you. I said, what's that? I said, are you aware? I saw a stat the other day that I think it's 5% of whites own more wealth than all of Black America. Let's just digest that. That few people own more wealth than 2,400 Blacks in America. 24 million. 44 million. I said, if you don't think I'm wrong, you go ask Bill Cosby with his billion different. You ask Kanye West with his billion different. And if she says the wrong thing, you can go ask her. I mean, I think they got 1 billion, nobody's got 2 billion, they say Elon got 107 billion. And let me tell you something about billionaires. I've said this for years, because when I work with them in New York. I said, you get 1 billionaire in the room, and he thinks he's God. You put 5 of them in the room, they know they're God. And that's what Trump is proving. All they got to do is get those billionaires who think they're God, and when they all get in the room together, they sit around and say, hey, all this is subject to us. Then they're going to say and do what they want to do. But the challenge is, the law is the second best thing. And what's the best thing? It's faith in God. See, we got here, and I had a guy from Scotland when I was in law school who explained this to me. I didn't understand it. Then my mentor had said it, that I could see what he was saying. He said, when America was founded, they had no intentions of blacks being a part of it. It intended blacks were the economic development policy. Slavery was an economic development policy. You know, they say mechanization and concrete over slavery. And they needed labor, so they went and got it. That's what we're here for. And then once they got free, like, what the hell are we going to do with them now? Because we shouldn't bring them over here to be citizens. And that's why I said the Lincoln's assassination, because he started talking about he had to give the slaves, the soldiers who fought in the Civil War, and the rule at the time was, if you were from Italy and you came to America and you were a white male and you had fought in the war, you didn't get citizenship. See, citizenship was first reserved for those who fought in the war, then it became landowners. So once the blacks joined the Union and saved the Union, fighting,
they were automatically, according to the doctrine, entitled to citizenship. That's how blacks eventually got citizenship as a whole. Remember when the 15th Amendment was passed, white women couldn't even vote. All right, so that's a part of it. And so now what we're dealing with is, how do we address that? And we got to address that one way. Our ancestors came and made America hold true to its promise. And that's what Martin Luther King's speech was about. He was recognizing that you wrote a blank check. You didn't put my name on it, but I put my name on it. And guess what you're going to do? You're going to honor it. So the law can make you do that. But you got to have faith in God, because the last thing I'm going to say is what Dr. Thompson said to me, and I'm going to leave it with you. I think I probably. He told me a story, he told it to me 10,000 times, Katz, about the Chinese Revolution. They were fighting, and one of the old guard came to the gate and said, open the gate. And outside the gate, he saw the biggest peasant that was fighting, beat the door. And he called him to the gate. He said, hey, you, come here. So the peasant came, and the peasant tried to break in with all the rest of the peasants. He said, if I let you in, will you help me keep the others out? And I said, okay. He said, you don't get it. I said, I don't get it. Maybe you can tell me, I'm not that smart. He said, when we were doing the civil rights movement, we had one Achilles heel we couldn't resolve. Once all these blacks get in, who are they going to be loyal to? Are they going to be loyal to the cause? Yeah, if they continue to get in and they get that big promotion and they get loyal to the cause, they don't get fired. So their families going to have to move from the suburbs and move back to the ghetto. Or they're going to be loyal to the jobs. And one of the problems that Jay Meredith, that immigrated Ole Miss, said, that when he got recruited into Columbia, Dean Bill Warren, who was a partner in the firm I was with, told him that somebody said, there's no problem with opening up our law schools and our business schools to blacks, because they just don't want to get rich, and they're going to cease to fight for their people. And that's our challenge today. Our best and our brightest are concerned with making money, even though more and more blacks are being enslaved and below the poverty level. And so when you say belief, and then the law can be a point, but it can only be a point if people are willing to use it and willing to fight for it and willing to be ostracized for fighting for it. But as long as all we're concerned with is making sure I can pay my mortgage and making sure that I don't get fired, then I don't want to say there's no hope. I want to say the hope is less. How about that?
I do want to once again thank Bowie State University, Dr. Adams, Dr. Parrish for allowing us to have this outstanding forum today. Let's give our panelists another round of applause. Thank you. And we'll be around if anybody else has any further questions. Thank you, guys.